My name is William S. Harris. I go by Bill, and I have been practicing law here in Tarrant County for 40 years. Excuse me. What should a gun owner tell the police once they've used their gun in self-defense? That is a very simple question with a very complicated answer. To some extent, as a defense attorney, my knee-jerk reaction is to say nothing but your name, rank, and serial number. As a practical matter, you always need to be cooperative with the police, polite. You can answer demographic questions, meaning questions about who you are, where you live, how old you are, anything like that that's not what your date of birth is. That's fine. Be cooperative and give that information. You probably in this situation, for the reasons I explained before, are going to have necessarily already identified yourself as the person who used the firearm under the circumstances and that made a simple statement that you believe you've acted in self-defense. That's it. That's as far as you need to go. Some lawyers, being even more conservative, would say that's farther you need to go. You're just simply who you are and that, yeah, you did this and you don't have anything more to say. When the police start asking you for more details than what I've just said, don't start trying to explain this thing away. And there are a couple of reasons for that. The most important is you are not going to be cool, calm, and collected, I hope. You're going to be emotionally upset. You're going to be emotionally traumatized by what you have been through, what has happened to you, and what you have just done. You are not reflecting coolly, and you do not know how what you're saying is being heard by those who are listening to you. And just as you might say to someone, I'll give you a classic example of something that's never construed the way it's intended, or maybe it is sometimes. You've got somebody that's accused of being inappropriate with a child, and it's their stepchild, and the first thing they say is something along the lines of, when I married her mother, I thought I was getting 2 for 1. Now, they may mean that in the sense that they were getting an instant family, that they were getting a child to love platonically and a wife to love as you do a wife. That's not how it comes across. And that's an example of somebody saying something that may have a different meaning to the speaker than it does to the person who is hearing it. The same thing applies across the board. Almost anything we say, that's why communication is an art, not a science. Almost anything we say can be misconstrued. And depending on the circumstances, I would say will be misconstrued. I've represented lawyers in grievance settings where the lawyer is trying to explain something, and this is a person who's used to being in that situation, and they make a statement, and they think they have explained what they were talking about. But me, as the person listening to the statement, realizes that at best it's ambiguous, and at worst it may literally be a situation where they're misunderstood. That is somebody that is not in the kind of situation you're in if you just used a firearm. You just need to, I don't have a problem with you saying I acted in self-defense, but you don't need to explain why, you don't need to explain anything else. You just say that and then let the course evolve. If they try to ask you for details, ask for your lawyer. Here's the other thing to remember. People watch a lot of TV. I do too. There is no requirement until you are in custody that the police warn you of your Miranda rights before anything you use can be used against you. Anything you say can be used against you. If you're not in custody and the police have just arrived, everything you say is fair game and you're creating evidence in the case. And the fact that you haven't been warned of your Miranda rights is totally irrelevant because you're not yet in custody.